So hello everyone and welcome to MCLE This Week. I am your host, Program Attorney Bruce Richard. On this episode, we're joined by Mike Sams, Litigation Practice Area Co-Leader at Bowditch Dewey, Chair of MCLE's Making Objections Workshop, and member of MCLE's Board of Trustees. Welcome, Mike.
Thanks for having me, Bruce.
Thank you. So, Mike, let's jump right into the merger. So, your firm, Kenny & Sams, merged with Bowditch Dewey at the beginning of this year. Why? I'm assuming I want to talk about the benefits of the merger.
So Sure. Good question. So just because we're lawyers, I'll start off by saying that technically, legally, it's not a merger. That as Kenny & Sams winds down its business, our lawyers all move over and join Bowditch, but colloquially, we'd all refer to it as a merger. Really exciting time for us. I'll tell you why we did it, and also what I see as the benefits already.
Yeah.
The why is, as much as Chris Kenny and I, my longtime partner, like a brother, loved having our firm and managing our firm, there were two things that we were looking for as we continued to grow when we were Kenny & Sams. One is more resources, and two is knowing that we've got stability forever.
Right.
And so in terms of the resources, and this also answers your question about sort of how has it been.
Right.
What we get with the Bowditch group is, we go from being 20-something lawyers to 70-something lawyers.
Right.
So we get a lot more experts in the law. Not only do we get depth of personnel, we get depth of practice area. Mm-hmm. So whereas Kenny & Sams was a trial law firm, risk management group in the areas of just about anything you could try a case in, with a lot of work in construction and employment and business disputes. Now we have practice areas across the board. When clients call me and they need a corporate matter addressed, or they're looking to buy a piece of property and develop it, they got a tax question, they got an estate planning question, whatever it is.
Right.
I'm that person now who can say, I got a guy for that.
Right.
Only I feel like we were always able to do that, but instead of saying I got a guy or I got this great woman who I know is going to be a great service to you, and then I would send them out, now I got it in-house.
Right.
I can stay in touch with the client. I know they're getting great service because Bowditch is just chock full of terrific lawyers with a really nice touch in terms of working with people. It gives me a lot more resources for the clients. The other thing that it accomplishes, that Chris and I talked about a lot over the years, was stability. And not just stability in the here and now, because I felt like we had that with Kenny & Sams, but stability forever. In that, Bowditch is the oldest firm in central Massachusetts. It's going on about 110 years old.
Right.
We join them. Our folks who join, we know, Chris and I know that these great lawyers that we were so proud to work with at Kenny & Sams, they've got a home for the rest of their careers.
Right.
Bowditch is going nowhere ever.
Yeah.
For 110 years that's been the case. And for the next 110 years it'll be the case. So we get both stability and depth of practice and expertise. It's been just absolutely wonderful.
Nice.
Yeah.
So how has it been? I mean, it's barely a month, but how has the transition gone? So
it's been time consuming and very productive. Yeah. Time consuming part of it, of course, is, and I could have never imagined this piece of it because I'd never been through this sort of thing before. The amount of administrative that has to happen as part of the process is enormous. And when I say that, it almost sounds like I'm doing it. I'm not really. We've got a ton of people who are making it happen, but it's everything from new engagement letters. Because we're now under a new firm, we have to have new engagement letters. So all of our clients got to get new engagement letters. And sometimes clients aren't as fast to get them back because they got a million things going on. So you send them out, and then you got to follow up, and then you're getting them back. We got to transfer all of our electronic files over.
Okay.
We got to learn how to use the new software and the billing systems and all of that. So thankfully, Bowditch has really good systems in place, and it's been a really organized training process. But it's a lot, and it's a lot for really for the staff and for the lawyers.
Right.
But it's been going great. The process, as much as it's been a lot and time consuming, it's been really well run. And on top of it, sort of connecting back to one of the answers I gave a second ago about depth of practice, we've already had this great experience of being able to refer clients. I've gotten to refer clients over on employment and real estate and estate planning and corporate, all of those things in just this short time. Multiple of those in all of the different areas. And we've been the beneficiary of work coming over from corporate department or from the estate planning group or something like that where they need litigators. Bowditch had litigators, some really terrific ones, but we're a much bigger resource. You know, we come in as 20 more lawyers, and there's a lot more resources to do that sort of work. So it's been fantastic.
Yeah, it's nice to know when your referral service is your own firm.
Yeah, well said. Well said.
So, for folks who are looking at something like this coming up in the future, or who are considering it, what sort of advice do you have for them? I mean, like you said, you hadn't had a chance to do this yet, so now you've got a little more experience. Any suggestions for folks?
Yeah, I mean, if you're looking at it from like the way and for the reasons that we did it, it can be a great thing, but you got to pick the right partner. You know, like I didn't know when Chris and I started Kenny and Sam's back in 2006, how much the partnership was a business marriage. Yeah, and I'm grateful and thankful and lucky that I picked the right guy to have this business marriage with for 20 years, and it worked out splendidly. It's the same thing when you're moving over to another firm. You have to make sure it's the right fit. And so, you know, we had, a lot of meetings with the folks over at Bowditch to get comfortable. And then we met with their capital partners, and we met with their other practice group area leaders to make sure that it was comfortable for us, and also so that they could make sure they were comfortable with us.
Right.
So one, I would say, don't do it lightly. But the other thing is, I said don't do it lightly because you might not end up with the right folks. Now, for us, we ended up in just the perfect spot. But I say the other thing about moving around generally, Bruce, and it's prevalent in our practice now.
Right.
I would say to people, don't do it lightly. That thing that our parents used to say to us, or that mentors used to say to us when we were young growing up, is true. The grass is not always greener.
Right.
No matter what we do as lawyers, I think it's hard work. It's a tough profession that we chose, and a challenging one, and for those reasons also some of the most fulfilling work you can do.
Right.
But it's going to be hard anywhere. And I think sometimes people make the mistake of thinking, if I switch from X to Y, everything's going to be better, and the grass is going to be super green, and it's going to be easy and fun, and none of the stress things that I've got at the current place are going to. I say that because I, having interviewed lots of people over the last 20 years as part of growing our firm, I've seen a prevalence of people at firms for a year and 2 years, and then they move to the next firm for a year or 2 years. And one is sort of proof that the grass is not always greener because they're bouncing around from place to place. It also, when you're moving around too much, I think doesn't allow you to really get stability as a lawyer. That is, you have no foundation really if you keep moving from place to place to place, and it inhibits your development of relationships. It also, I think, sometimes may cause clients to wonder, geez, my lawyer keeps moving and bouncing from place to place to place, which is sort of an unsettling thing for clients.
Right.
So I think overall, the prevalence of moving in the profession that we have is, I wish there was less of it, but maybe I'm just an old man shaking my cane at the clouds, because I do see the value in staying in a place and really putting down roots there.
Right.
On the bigger level, if you're actually going to move firms, like we did, and move large groups of people over and join something else, do it slowly, do it with trepidation, and to make sure you've got exactly the right fit. And like I said, that's how it worked for us, and it's just been, I couldn't be happier. Was
there a moment when you were like, no, this is definitely the right fit? Was there something that happened, or was it just sort of a general move, and this made sense?
Yeah, it was a general move with no. I will say there were no ever any setbacks, but because we're all busy people, busy lawyers on both sides, it was a long process, and it wasn't any one thing that we just said, boom, we're in, or that they said. I don't think it was any one thing that made them say we're in. It was this period of time where we sort of, an analogy, we dated for a while.
Yeah.
And it wasn't until, the end of the year, actually,
Right.
that we all said, let's do this.
Yeah.
Until then, there was still, feeling out and trying to assess whether it would be a good thing or not a good thing.
Right.
But the number of meetings got us all comfortable.
Okay.
Yeah.
All right.
Yeah.
So let's completely jump tracks here. So you're chair of MCLE's Making Objections workshop, and we've been doing this for a little while now.
A little
while. I know that when I first came to MCLE, this program had already been running for a while, and I remember one of the first things I saw with this was Making Objections workshop, and it runs for a half a day, and I said to myself, how does this program run for more than an hour? There's what is there to discuss? So, Mike, what is there to discuss? Because I know this is a 12 to 5 program, and most times when we do this, we're here past 5.
Well, it's funny you say that, because if you remember, when we first did it, it was a 12 to 4 program,
yes.
and we found we were constantly running until about 5:15.
Yeah.
So you said, well, guys, why don't we extend it to 5 so nobody feels like we're keeping them extra? And by the way, try to get it done by 5 instead of 5:15, I think were your words. It is a now long-running program. I think this is probably like 6 or 7 years that we've done it, and it's been me and Peter and Jack, and then we've had a handful of different judges that have come through that have all been fantastic.
Yeah.
And Peter and Jack and I don't kid ourselves. We know people come for the judges. But I feel like the program has worked really well, Bruce, because I think Jack and Peter are extraordinary lawyers, and not just I can see not just why they're good in front of a jury, but they're really good technically.
Right.
And that's really what we focus on in the Making Objections workshop. So as you know, the first hour and a half or so, we're talking about different areas of evidence and making objections, and then the judge will give her sort of state of the law on making objections, and then we take a break, and the real meat of this is, and after we've done our presentation on sort of critical issues that people should be thinking about, we give them a couple fact patterns, and we play act it.
Right.
And as part of doing it, the participants have to get up on their feet, and everybody has to do it, and stand up and make objections.
Yes.
And they do it with, Pete. It's usually Peter questioning me on a fact pattern, and I'm playing the role of a witness, and he's playing the role of either the prosecuting lawyer or the defending lawyer. And the students in the program are supposed to stand up and make objections when they think it's appropriate to make an objection. And it's usually, for each scenario, we'll have about 4 lawyers up there, and it's between the 4 of them just to have the judgment to stand up and make an objection and explain their objection. And the real neat thing is we always have a judge in there.
Right.
Judge is in the robe, and judge is giving it a sustained or overruled, and we'll go for about 20 minutes, and then we break it down, and we sort of, if it was football, you'd say go to the film. We do a film talk. We review the objections that were made, and between all of us, the judge and Peter and Jack Perzola and I, we review sort of our comments on the objections they made. But it is the fact that these people have to get up on their feet and in real time make an objection, and not only make it, but maybe explain it if the judge asks, is the really educational piece for them. Is the really educational piece, because it's not just reading about it.
Yeah.
It's actually processing it and knowing in that moment,
Right.
I got to object.
Yeah.
And sometimes while they're standing up to make the objection, I think, because at least this is the way it's been for me in court sometimes, as I'm standing up to object, I know I got to object, but I'm not even sure yet what I'm going to say as a basis for my objection until I get fully up on my feet.
Advance your practice with the MCLE Online Pass. For one monthly subscription fee, you can access everything MCLE has online: live and on-demand webcasts, ebooks, forms, checklists, and more. Start your free trial today at mcle.org/onlinepass.
the workshop emphasized not just how to object, but when not to.
Yes.
So why is restraint as important as, the assertiveness in the courtroom?
So as much as you want to use objections to keep out the things that shouldn't come in, or things that might hurt you that could potentially come in but aren't being introduced the right way, right? You're trying to safeguard your case as best you can. If you're just objecting all the time, the jury's going to see you. I think the jury could see you as an obstructionist.
Right.
If somebody asks you a leading question about your name, that would be a bad question.
Yeah.
But is it really? Yes, technically objectionable. But why?
Right.
Why? And so part of what we talk about, and part of the commentary we'll give after they've done their mock objections, is not only did they get it right, and if so, why, or if they didn't, why they didn't get it correct, but did you really need to?
Yeah.
I think as a young lawyer, for sure, it's better to err on the side of objecting than not objecting. And like anything else in life, the more you do things, the more trials you have, the more you get a feel for, this is a line of questioning that I don't need to object to.
Right.
And I don't want to object to.
Okay.
So that's really it. It's part of overall as a trial lawyer. You want to connect with the jury as best you can,
Right.
and being seen as the obstructionist is not helpful.
Right.
If on the other hand, you're objecting on the stuff that you're appropriately objecting on, and that has some significance, and you're winning most of those, the jury doesn't see you as an obstructionist. They see you as somebody who, doing your job,
Sure.
and actually, because the judge is sustaining you, maybe aiding the trier of, the fact finder,
Right.
in its job.
Okay. So, as I said, we've been doing this program for a little while. So you've seen a lot of these new litigators. So, what's
Bruce,
most?
You say a little while. It's like you're from Canada. You might say Canada is just another little country. It misses the mark. We've been doing this about 6 or 7 years.
Oh, I think it's even more than
More
that.
than that.
Because
Yeah.
I started assisting with this program about a year before COVID, and I know you guys had been running well before that. So that would have been.
That sounds about right.
So I think if it's not 10 years, it's pretty close.
Well, we've been doing it long enough that I
So-
know all the cross-examination questions Peter Ball's going to hit me with when we're doing our program.
So you've seen plenty of the new litigators coming through. What is most often misunderstood about objections? What sort of bad habits do you see these newer attorneys coming in with?
I've actually been really impressed with the folks coming through. I was going to say younger, but sometimes it's more senior people who just haven't done it as much. I'd say that they're well ahead of where I was when I first did this. In fact, just short story. Back when I was in law school, I did this mock trial program. And one of the things that we did as part of the mock trial training was sort of a mini what we do at MCLE. It was a training on objections.
Right.
And back then they'd video it for you on one of those big 8-tracks. Remember those?
Yeah.
And so I had this 8-track tape, and I'd thrown it up I'd looked at it when I got home, and then I put it up in my closet. And then I get married, and one day I come home from work, and my wife's there a little bit ahead of me, and she says, I was cleaning out the closet, and I came across that cassette tape where you're doing something at the courthouse, or the mock courthouse. And don't get me wrong, my wife is awesome and been a big supporter, but she says to me, "You've gotten better, haven't you?" For real. And I said, I hope so. I think I've been practicing for a couple of years then. The point is, I don't really think with the folks when you're getting started at this, it's a misunderstood thing other than maybe I object on everything, which you don't need to. Maybe that's a misunderstanding. I think it is really just a matter of, learning how to be a good driver. Get out there and do it again and again. Get as many opportunities as you can.
Right.
Take depositions. Start figuring out when you're going to make your objections and get comfortable doing it. It's not really a huge... It's not a misunderstanding. It's a lack of experience.
Okay.
I will say this, though. For younger or newer lawyers, if you're going to be a trial lawyer, there's multiple parts to it. Part of it is sort of being a private investigator. Your job is to gather the information.
Right.
And of course we can do that through the rules of discovery, but there's also sometimes just hustling, getting out there and finding witnesses and getting an affidavit or public records requests, harvesting the information. That's part of it. Another part of it is assimilating that information in a way that fits into your case and starting to figure out, what's my theme? What is the theme to my case? How am I going to present this case? How am I going to tell it to a jury? And then the overlay of that is, how does it fit within the rules of evidence? Because if you're the greatest hustler in getting information and you're a great storyteller, but you don't master the rules of evidence, maybe only half your story's getting in.
Right.
So every piece of that information that you're pulling together to fit into your story, I would say the tip that I would give to younger lawyers coming up is, don't just look at the information as helpful or hurtful. Look at it through the lens of a true trial lawyer and say, how is that coming in? How do I get that in? Or how do I keep it out?
Right.
That's maybe a piece that is missing initially. Even though we all get taught evidence in law school, it's really not until you start getting a lot of practice at it that really comes into focus.
Right. So the workshop is offered exclusively in person with a mock courtroom component that we've already talked about a little bit. What does experiential learning adds that the traditional lecture just doesn't?
Well, first off, listening to a bunch of lawyers stand in front of you talking about evidence and objections for a couple hours, I think could get mind-numbing. As much as we try to spice it up, and I like I said,
Right.
I'm blessed with these great folks on the panel with me who are terrific. It is that the getting up on your feet,
Right.
and that split second of processing, what I was referring to earlier, that split second of standing up and processing, I know I'm supposed to object, but why? That is what you really get out of it. You start to get some practice at getting better at it. You also just get the sense of what it's like to be in a courtroom and have to do it.
Right.
So that maybe, if nothing else, when you leave, you walk away from this program with more foundational training on the rules of evidence
Right.
and objections, and having been put through your paces a little bit, you walk away going, you know what? I got to look at I got to master the rules of evidence a little bit better,
Right.
so that this stuff is really second nature to me. I can tell you, I say that that's for folks who are coming through our program, but it is just about as much not lost on me. Every time I do this program, I come away from it
Right.
thinking about cases that I have going, and oh my gosh, I got to really focus down on this or that issue in the case.
Sure.
Otherwise, it's going to be objectionable.
Right.
Or I may have an out. I may be able to kick that piece of evidence out. So it's just I think it forces you to, having gone through the experience, to walk away and think about your own cases
Right.
and how these rules of evidence and objections fit into your case.
So we also did this during COVID.
Yep.
How do you compare the Zoom version versus the live version?
Yeah.
I think I already know the answer.
And
but
you tell by the look on my face.
Well.
I think it was great that MCLE did it during
Yeah.
COVID. We really had no choice, and we had a great turnout.
Yeah.
I thought, as with everything else, MCLE really did a great job running it. There's nothing better than doing it in person, actually having to stand up in front of a judge and a bunch of seasoned lawyers who are part of running this program, and make your objection and just sort of feel the heat a little bit.
Right.
It's nerve-wracking to do that as a young lawyer, but it's part of the process of becoming a real trial lawyer that I just don't think you get doing it on screen.
That makes sense. So you've worn many hats here at MCLE. So you've been a program volunteer, you've volunteered with the books, you're a board member. I know that you served as board president for a while. How has that range of experience shaped the way you think about continuing legal education?
Oh, significantly. Like anybody else who starts out coming to MCLE as a young lawyer, and I had the benefit of being told, go to MCLE to take some different courses as to supplement in-house training at the firm I was at. I came initially as more of it felt like it was a field trip. Like, when you're in high school and you go on a field trip, I felt like it was a field trip. And I'm not sure I took it as seriously as I should have. As I became more of a senior lawyer, I could see the significance of and how well the training was provided at MCLE. So for me, it was a trajectory of coming to MCLE for programs, initially not taking them probably seriously enough as a brand new lawyer, becoming a more seasoned lawyer recognizing that, wow, there's some really good training here and I can get ahead of the curve, to then eventually getting on the other side of it and becoming moderating a program and speaking at a program. Those make you an expert. If you're not already an expert in that field, they help make you an expert in that field. They also make you feel like more of a real professional. I've always said that being a lawyer is something. It's a really proud profession. You should be proud of doing it.
Right.
You haven't just arrived once you pass the bar and you start practicing law. The art of being a good practitioner is always continuing to learn, and that's what MCLE provides.
Right.
So for me, again, starting and then taking more courses and then presenting and then getting involved in MCLE on the board and as the president for a couple years, it's really given me perspective on how great MCLE really is, the breadth of services that it provides, and the real depth of quality that it provides.
Right. Yeah. I mean, I was going to go into sort of what does volunteer service here offer to the folks who are doing it.
Yeah.
I mean, I sit on this side, I'm one of the employees. I don't sit on the other side. I mean, what I see are a lot of volunteers, and I'm very lucky because the folks that volunteer at MCLE right across the board are always spectacular people to work with. But what I don't hear is why they're doing it in the first place. So
yeah, I think there's a couple reasons. One, I think most of, or at least a lot of the folks who present, they want to be part of this proud profession. They want to give back.
Yeah.
That's a huge reason that I continue to do it. I think there's another facet to it. You make some good connections. You make new friends. People I've been on panel presentations with, I've gotten to be friends with. There's a good networking to it. It gets if you haven't already done it and you're trying to establish yourself as, maybe one of the premier practitioners in your area.
Right.
What better way to do it
than
at MCLE, writing something and then getting up there and speaking about it to fellow bar members, fellow practitioners who are now going to know you're sort of at the pinnacle of whatever it is that they're there to study.
Right.
I don't know if there could be any better marketing than that. So there's a marketing component to it. But I really think, especially for some of us more senior lawyers, it is at that point, it's really just the enjoyment of giving back.
Excellent. And if folks think that this part sounds like an ad to come and volunteer at MCLE, then take it as that. Please reach out to me. My email is in the program description. So we're always looking for more faculty. Mike, I want to thank you for joining us here today.
Thanks for having me.
Just a reminder to everybody: the Making Objections workshop, April 1st, 2026. It's from 12 to 5. Please check it out on the website. There will be a link in the show notes. Mike, thank you so much.
Thanks for having me, Bruce.
All right.
We look forward to seeing you at the Making Objections workshop.
Yes, look forward to seeing everybody there. Talk to you soon.
The MCLE This Week podcast is a production of Massachusetts Continuing Legal Education in Boston, Massachusetts. For sponsorship opportunities, email us at podcast@mcle.org.